In the world of legal battles, there's this one tool. It's so powerful, it can literally end a case before it ever gets near a courtroom. It's called a deposition. And honestly, it's probably one of the most misunderstood high-stakes moves in the entire legal playbook. And this quote just nails the central puzzle, right? How can something be both overrated and also give you advantages you can't get anywhere else? That's what we're going to dig into. Because a deposition, it can be a total waste of time and money, or it can be the single sharpest weapon you've got. All right, so first up, let's talk about why people think they're overrated. And it's actually pretty simple. If you go into a deposition without a solid strategy, well, it's kind of like showing up to a gunfight and having no idea how to pull the trigger. Okay, so let's make sure we're all on the same page here. What is a deposition? Basically, it's just sworn testimony that happens before a trial. You can think of it like a dress rehearsal for being on the witness stand, except, and this is a big except, everything you say is recorded, it's under oath, and yeah, it can absolutely be used against you later. And that brings us to maybe the biggest rule of all. You just don't do a deposition for the heck of it. It's a purely strategic move. You only pull this trigger when you absolutely have to get information you can't get any other way. So you might be thinking, if they're so risky and they cost so much, why even bother? Well, the answer is simple. It's all about what happens when you get people in a room, face to face. See, this is the magic that a stack of papers can never, ever give you. You're not just reading words on a page. You get to see the person. You can hear that little hesitation in their voice. You can see that flicker of doubt in their eyes. Those are the human tells, the things that show you what's really going on behind those carefully rehearsed answers. And get this, you could even show a jury how they squirmed on videotape. I mean, think about that. It's not just about what they said, it's about how they looked when they said it. Every nervous twitch, every uncomfortable shift, it's all captured on camera, and you can play that right back for the jury. Wow, talk about powerful. So let's just break this down real quick. On one side, you've got what's called paper discovery. Written questions, the answers are all polished, the lawyers have gone over them, they're totally sterile. But a deposition, that's a different beast entirely. It's live, it's happening right now, it's messy and spontaneous. And that's where you find the real stuff, the gut reactions, the emotional tells that a piece of paper just can't show you. Okay, so we know they're powerful, but how do you use them the right way? Here's the secret. It's not actually about the deposition itself. It's about all the homework you do beforehand. Think of your investigation like a movie. The deposition, that's the grand finale, not the opening scene. So take a look at the proper order of things. A smart lawyer doesn't jump straight to a deposition. No way. First, you've got interrogatories. Those are the written questions. Then, requests for admissions to nail down facts. Requests for production to get all the documents. You might even use subpoenas. You're building this huge foundation of evidence, piece by piece. The deposition is last. It's number 5. It's the final step where you use everything you've gathered to lock that witness into their story. And this really is the mantra you have to live by. Always know all you can before deposing anyone. You should be able to walk into that room knowing the answer to almost every question you're about to ask. A deposition isn't a fishing expedition. It's not for finding new stuff. It's for getting the other person to say, on the record and under oath, what you already know. And that's the whole strategic shift, right there. You're not there to explore. You're there to execute a plan. All your research is done. So you're not really asking questions to find answers. You're asking questions to lead the witness right where you want them to go. But that leads to the big question, doesn't it? How do you actually make them tell you what they know, especially if they don't want to? You've got the evidence, but how do you get them to admit it? Well, it comes down to asking the right questions in the proper sequence. It's not a conversation, it's a game of chess. Each question is a move designed to box them in. You use the facts, the documents you've gathered, and you build this little trap until they have nowhere to go but to tell the truth. This is not the time to wing it. And you absolutely have to nail it, because guess what? You usually only get one shot at this. That's it. One deposition for each witness. The pressure is on, because if you mess it up, the next time you see them could be at trial, in front of the jury. And this is a really important legal point to understand. At a deposition, the rules are pretty broad. You can ask about anything that's reasonably calculated to lead to the discovery of admissible evidence. You can cast a wide net. But at the actual trial, nope. You can only talk about evidence that is actually admissible. So you can't wait until you're in front of the jury to start digging for new info. The time for that is long gone. So, After all this work, what's the ultimate payoff? What's the real goal of a perfect deposition? It's actually not just about getting facts on the record. It's about winning the entire case before you even get to trial. Yeah, the real goal is to know what they're going to say and how to catch them in a lie. This is where a deposition becomes an offensive weapon. You lock them into their story. Now you know exactly what they're supposed to say at trial. And if they dare change one little detail, bam, you pull out their deposition transcript and show the jury they're a liar. Their credibility? Gone. And that's how clever lawyers do it. They encourage their opponents to settle. Because why would you want to face the embarrassment of getting dragged into court where you're going to be exposed for the scoundrel you truly are? A great deposition makes the other side see that they're going to lose. And when they see that, they settle. Case closed. You win without ever stepping foot in a courtroom. So it leaves us with this question, right? In this whole pursuit of truth, is the goal to just get the facts, or is it to win the fight? A deposition is supposed to be about finding facts, but in reality, it's a battlefield. It's all about strategy, tactics, and gaining an edge. It's a pretty stark reminder that sometimes the law is less about finding the truth and more about winning the war. Something to chew on.